Magandang umaga sa inyo lahat. So, ako nga po pala si Mr. Rolan Sy from Amparo High School. At ngayong araw ay ating pag-uusapan ng sexual harassment in a work-related education or training environment, other known as Republic Act number 7877, Anti-Sexual Harassment of Act 1995. So, what is the present law on a sexual harassment in a work-related education or training environment? Republic Act 7877, an act declaring sexual harassment unlawful in the employment, education, or training environment. And for other purposes, the law was approved on February 14, 1995 and became effective on March 5, 1995, 15 days after its complete publication in the Malaya and the Times Journal on February 18, 1995. It is more popularly known as the Anti-Sexual Harassment Act of 1995. Section 1, Republic Act number 7877. What is sexual harassment in a work-related education or training environment? Section 3 of Republic Act 7877 defines sexual harassment as an act committed by an employer, employee, manager, supervisor, agent of the employer, or any other person who having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted by the object of the said act. So, ang sexual harassment ay hindi po siya porket inaccept at hindi inaccept ay hindi na po siya matatawag na sexual harassment as long as ang sexual harassment ay naganap sa work-related or education training environment ay pwede pa rin po itong mapunta sa Section 3 of Republic Act 7877. Elements of Sexual Harassment Act of 1995. First, the offender is an employer, employee, manager, supervisor, agent of the employer, or any other person. Such offender has authority, influence, or moral ascendancy over another in a work or training or education environment. The offender demands, requests, or otherwise requires any sexual favor from the other regardless of whether such demand, request, or requirement for submission is accepted by the object of the said act. First element. Offender is an employer, employee, manager, supervisor, agent of the employer, or any other person. Practically, it's anybody. Pwede siyang maging babae, pwede rin siya maging lalaki. It's not always the opposite sex yung nagkakaroon ng sexual harassment. Pwede rin po siya sa babae at kapwa niya babae. At pwede rin naman po ito sa lalaki at kapwa niya lalaki. Male or female can be an offender, provided the second and third elements likewise exist. Note, the victim and the perpetrator can be any gender, and the perpetrator does not have to be always an opposite sex. Yun nga, sabi ko kanina. So, hindi porket lalaki sa babae, sila na lang yung nagkakaroon ng sexual harassment. Nangyayari din po ang sexual harassment sa kapwa lalaki at sa kapwa babae. Second element, such offender has the authority, influence, or moral ascendancy over another in a work or training or education environment. Authority means the power or right to give orders, make decision, and enforce obedience. A person or organization having power or control in a particular, typically political or administrative sphere. Influence means the capacity to have an effect on the character, development, or behavior of someone or something to affect or change how someone or something develops, behaves, or thinks. Moral ascendancy is commonly used as the synonyms for moral high ground, but in law, it can refer to a position of authority that can be abused. Usually, in cases of sexual coercion, moral ascendancy takes place of violence, threat, or intimidation in rape cases. Work or training or education environment means that sexual harassment may take place in the premises of the work or office or of the school or training institution, in any place where the parties were found as a result of work or education or training responsibilities or relations, or at work or education or training related social functions, while on the official business outside the office or school or training institution, or during work or school or training related travel. It can be also by telephone, cellular phone, electronic mail, or any other form of social media communication. So, ang sexual harassment, hindi lang siya nagaganap sa trabaho, sa eskwelahan, kundi kahit saang lugar po ito nangyayari. Pwede po nating sabihin na nag-communicate ang isang perpetrator dun sa kanyang binibiktim. Pwede rin po siya through physical contact or any kind of sexual harassment. So the third element, offenders demands, requests, or otherwise requires any sexual favor from the other, regardless of whether such demand, request, or requirements for submission is accepted by the object of the said act. Should the demand, request, or requirement be explicit? No. Demand of sexual favor need not be explicit or expressly stated. While it is true that Republic Act 7877 calls for a demand, request, or requirement of sexual favor, it is not necessarily that such demand, request, or requirements be articulated in a categorical, oral, or written manner. It may be discerned with equal certitude from the acts of the offender, as long as the act results in an intimidating, hostile, or offensive environment for the offended party. So let's have an example here, Example number 1. X as the manager and Y as the employee. So, X-manager of Y constantly holds the waist of the latter every time he passes by her work area. So, this is a good example of sexual harassment in work-related. So, kung lagi itong nangyayari, so pwede itong ipasok natin sa first and third element of Republic Act 7877, otherwise known as Sexual Harassment of 1995. Doon pa lang makikita natin na meron ng Sexual Harassment Act na nagaganap sa ginagawa ni manager through his or her employee. Next, example. X as a teacher or a senior high teacher, Y as a student. So, X, a senior high teacher of Y in one of the subjects, will not give Y a passing grade unless the latter agrees to have a date with him at Jollibee. So, in these cases, wala tayong nakitang sexual favor na kinukuha si teacher to the student. But, kung babalikan natin yung the second element, it said that pag ginagamit yung authority niya to take demands or to ask for a favor, it can also be a sexual harassment. So this is a good example for for education related or sexual harassment in education, training, or grounds. When is sexual harassment committed? In an employment or work-related environment. In a work-related or employment environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of the said individual, or in granting said individual favorable compensation, terms of conditions, promotions, or privileges, or the refusal to grant the sexual favor result in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment of opportunities or otherwise adversely affect said employee. The above acts would impair the employee's right or privilege under the existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. So, let's have two examples again. So, tingnan natin kung ano yung makikita natin sa mga examples na to. So, the first example, ito yung may nireject, tapos yung second example, inaccept. Tingnan natin yung pinagkaiba ng dalawa. So, basahin natin yung first example. X as an employee of Y's company. So, si X yung employee, si Y naman po yung may-ari ng company. Okay. Is slated for promotion. Okay. Si X daw ay para sa promotion. So, Y, however, told X he would not promote her unless she gives in to his sexual advances. X refused. Y did not promote her. This is a plain and simple sexual harassment. Bakit kamo? Kasi nga, her refusal to grant the sexual favor resulted in depriving her of her employment opportunity. So, ginamit ni Y yung kanyang authority or power para hindi ma-promote si X. Kasi nga, hindi na pagbigyan yung kanyang favor. At dito, makikita natin na meron tayong nakikitang sexual harassment. Yung refusal niya na pagkakaroon sila ng sexual favor ay nag-result ng pagkakaroon niya ng hindi pagkaka-promote sa trabaho. So, basahin natin yung example number 2. X, an employee of Y's company, same lang. So, si X pa rin yung ating employee, tapos si Y pa rin yung may-ari ng company. Okay. X, an employee of Y's company is slated for promotion. So, again, promotion pa rin yung usapan. Y, however, told X he would not promote her unless she gives in to his sexual advances. Since X sorely needed the promotion, kailangan yung promotion, she gave in to Y's demand and they had sex. So, merong consent doon kay employee sa ginawa ni manager or ni Y's company or may-ari ng company. Okay, so nakita na natin na agad na meron tayong ginamit ni Y yung kanyang authority para magkaroon ng intimidating part para kay X. Si X naman ay nag-give in para po makuha niya yung promotion. Okay? Y promoted her, pinapromote siya. But Y wanted more. So, yung una, pumayag si X. This second time, gustong-gusto ulit gawin ni Y yung nangyari sa kanila. X, natakot si X, fearing that she would lose her job if she refused. So, she gave in again for the second time. So, nakita natin dito na yung demand ng pangalawa ay wala na po siyang kapalit na hinihingi. Pero, nag-give in pa rin si X as an employee dun sa demand ni Y kahit wala na siyang kapalit. Kasi, nagkaroon na tayo ng tinatawag na hostile or offensive environment. Hindi na safe para sa kanya ang environment. Kaya kahit anong gawin ni Y, parang feeling niya is makukontrol pa rin ito. Gets nyo? Okay. When is sexual harassment committed in an education or training environment? In an education or training environment, sexual harassment is committed, number 1, against one who is under the care, custody, or supervision of the offender. Number 2, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. Number 3, when the sexual favor is made a condition to the giving of passing grades or the granting of honors and a scholarship or the payments of the stipend, allowance, or other benefits, privilege, or consideration. Or number 4, when the sexual advances result in an intimidating, hostile, or offensive environment for the students, trainee, or apprentice. Question: can a person who does not have authority, influence, or moral ascendancy over another in a work or training or education environment can be held liable under the Republic Act of 7877? Or can a person who did not directly demand, request, or otherwise required any sexual favor still be held liable under the said law? So, question will be answered as yes. Bakit? Kasi any person who directs or induces another or commit any act of sexual harassment as herein defined or who cooperates in the commission thereof by another without which it would not have been committed shall also be held liable under this act. In the last paragraph of Section 3, Republic Act 7877. Okay, next. Do lewd comments constitute sexual harassment? Yung mga malalanding salita or yung mga parang offensive word. Okay? It is not necessarily, however, where these lewd comments create an intimidating, hostile, or offensive environment for the aggrieved person, then such act may be complained of as sexual harassment by the aggrieved party. Of course, to constitute the sexual harassment, such lewd comments must be uttered made by the offender who has authority, influence, or moral ascendancy over another in a work or training or education environment, and that the same should be akin to requests for a sexual favor from the victim. What are the forms of sexual harassment? Physical sexual harassment includes unwelcome, unwanted physical contacts, including touching, tickling, pinching, patting, brushing up against, hugging, cornering, kissing, and fondling, and forced sexual intercourse or assault. Verbal sexual harassment includes innuendos, suggestive comments, jokes of sexual nature, sexual propositions, lewd remarks, and threats requests for any types of sexual favor. Nonverbal sexual harassment includes the distribution, display, or discussion of any written or graphic material, including calendars, poster, and cartoons that are sexually suggestive or show hostility toward an individual or group because of sex. Giving favors, more attention, dropping cases, admission and readmission, in exchange for sexual favors, suggestive or insulting sounds, leering, staring, whistling, obscene gestures, content in letters and notes, facsimiles, emails, photos, text, message, tweets, and internet posting, or other form of communication that is sexual and offensive in nature. What is the duty of the employer or head of office in a work-related education or training environment to prevent, deter the commissions of act of sexual harassment? Okay? Promulgate appropriate rules and regulation in consultation with the jointly approved by the employees or students or trainees through their duly designated representative, prescribing the procedure for the investigation of sexual harassment cases and the administrative sanction thereof. The said rules and regulation issued shall include, among others, guidelines on proper decorum in the workplace and educational or training institution. Create a committee on the decorum and the investigation of cases on sexual harassment. The committee shall conduct meetings, as the case may be, with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incident of sexual harassment. It shall also conduct an investigation of alleged cases constituting sexual harassment. In the case of work-related environment, the committee shall be composed of at least one representative each from the management, the union, if any, the employees from the supervisory rank, and from the rank and file employees. In the case of educational or training institution, the committee shall be composed of at least one representative from the administration, the trainers, instructors, professors, or coaches, and students or trainees as the case may be. The employer or head of office, educational, or training institution shall disseminate or post a copy of this act for the information of all concerned. Section 4, Republic Act 7877. What are the legal remedies against sexual harassment? So, first is administrative action. Against the offender pursuant to Section 4, note, administrative sanction shall not be a bar to prosecution in the proper court for unlawful acts of sexual harassment. Independent action for damage against the offender under Section 6. So, under the Section 5, the employer or head of office, educational or training institution shall be solidarily liable for damage arising from the acts of sexual harassment committed in the employment, education, or training environment. If the employer or head of office, educational, or training institution is informed of such acts by the offended party and no immediate action is taken. Criminal actions for sexual harassment under Section 7, imposable penalty, imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 nor than 20,000, or both such fine in imprisonment at the dissertation of the court. Note, any action arising from the violation of the provision of this act shall prescribe in 3 years.